Okay, ladies and gentlemen, it is exactly 1 minute past the hour of two. Very good afternoon to you all. Karibu sana, and thank you for joining us in this very wonderful webinar session. My name is Gabriel Achaye, and I'm joining you live from the East Africa Law Society here in Arusha, Tanzania. And it's really an absolute honor to have you this afternoon. This afternoon, we are delving in quite an interesting area of practice, and this is in the area of arbitration clauses in contracts, and in particular, we'll be looking at strategies for flexibility, enforceability, and effective dispute resolution. As you may know, as East Africa continues to strengthen its role as a dynamic hub for trade and investment, there are complexities with commercial relationships that are increasingly growing. So this afternoon, we have an esteemed panel of speakers that is here to enlighten us more on this particular subject matter, and we'll be hearing from them shortly. But just to introduce our moderator, my good friend Rosalia Musyoka, who is an advocate of the High Court of Kenya. She practices with DLA Piper Africa, which is IKM Advocates in Kenya. She's a member of the Law Society of Kenya, the East Africa Law Society, and a proud member of the ELS ADR Committee and the ELS Women Lawyers Committee. Speak about juggling roles at the same time. She has she has experience in commercial litigation, arbitration, and Rosalia does advise financial institutions, corporates, government entities, multinationals, and other clients in complex commercial disputes before Kenyan courts and arbitral tribunals. She contributes to thought leadership in the field of dispute resolution, with particular interest in strategic use of arbitration and other forms to achieve efficient and effective outcomes. Karibu sana, Rosalia. We have you for the next 2 hours. You can take it away from here, and we'll be back at 4 to assess and ask our questions. Karibu. Please, our dear participants, before Rosalia comes, we're streaming this session live on Zoom and on YouTube. So if you've not followed us, follow us at East Africa Law Society. That's our official YouTube handle, and enjoy the session. Karibu, Rosalia.
Thank you so much, Gabriel, for the wonderful introduction. And today's topic, as Gabriel hinted, is timely. It is timely because we are in the age where technology has reshaped the commercial and legal landscape, and it is imperative that the arbitration clauses we draft every day in our line of work adapt accordingly so that they continue to be effective. We are also seeing a lot of innovation-driven sectors come up almost every day. Talk about e-commerce, agri-tech, renewable energy, aka clean tech, and many, many others. And we cannot continue to draft our arbitration clauses the same way we have been drafting them. We have to catch up with the industry and the global landscape. No pressure to our panelists, who I will introduce shortly, but by the end of this webinar, we hope to have gained practical insight into drafting arbitration clauses that meet the dynamic environment that we are in terms commercially and legally, and also clauses that effectively serve the evolving business needs, regional realities, and international best practices. On that note, I have the great honor of introducing 5 incredible panelists who will take us through 5 sessions from now until shortly before 4 p.m. As we go, please feel free to drop your questions at the Q&A section, and our panelists will be happy to answer the questions. Not limited to questions, you can also drop your comments and compliments to the panelists, because I know that they are going to drop nuggets of wisdom. So the first panelist is Edith Tunamatsiko. Edith is an advocate of the High Courts of Kenya and Uganda. She has over 10 years experience in commercial, investment, and construction disputes resolution. She is a partner at Jojoma Advocates, the founder and executive director of African Women in Arbitration, and she's also a member of the Chartered Institute of Arbitrators UK and the East Africa Law Society ADR Committee. Welcome, Edith. The second panelist we have on our panel today is one that has a name that is quite tricky to pronounce, but I'll try. She's Frances Ingabire. Frances is a member of the Rwanda Bar Association. She has over 10 years of experience in legal practice. She's also a certified member of the Chartered Institute of Arbitrators and a certified mediator from the University of Cape Town, South Africa. She's a member of the Association of Young Arbitrators, and she's also the case manager and capacity building specialist at the Kigali International Arbitration Center. Welcome, Frances, and we are happy to have you today. Then third is Oscar Gadhura. Oscar is an advocate of the High Court of Kenya and a partner at Musili and Gadhura Advocates. He has extensive experience in dispute resolution across various sectors of our economy, including commercial law, corporate governance, employment law, intellectual property law, among many, many others. Oscar is a member of the Chartered Institute of Arbitrators, the Law Society of Kenya, and the Institute of Certified Public Secretaries of Kenya. Karibu sana, Oscar. Then we have Peter Njeru, OGW, and a fellow of the Chartered Institute of Arbitrators. He is an advocate of the High Court of Kenya and a partner at Kaplan and Stratton. He has over 14 years of experience in legal practice. He's also a seasoned arbitrator and a mediator, accredited by the Chartered Institute of Arbitrators and the Mediation Training Institute, respectively. Peter is also the chairperson of the East Africa Law Society ADR Committee, in which I am a member. Then finally, but not least, is Catherine Karaoke Mulika. Catherine is an advocate of the High Court of Kenya and a founding partner at Cavendry's Advocates. She has over 15 years of experience in legal practice, and interestingly, she particularly focuses on fintech, technology, telecoms, data, IP, and innovation, among others, which you will agree are very essential in the topic we are talking about. So we are very happy to have you, Catherine. Catherine is also a member of the Law Society of Kenya, the International Bar Association, the Commonwealth Lawyers Association, and East Africa Law Society. Now that we know our fighters, the ones who will help us unpack today's topic, I believe it is only right that we dive into it. We'll start with the first session, which will be led by Edith. Edith will talk about the critical balance between specificity and adaptability when we are drafting arbitration clauses. How specific should it be, and does specificity compromise adaptability? How do we create the perfect balance? Edith, you're welcome. Please proceed.
Thank you so much, Rosalia. Thank you for the kind introduction. I hope you can hear me loud and clear.
We can hear you.
Thank you so much. Yeah, so my job here is really to guide drafting an effective arbitration clause. What are the key preliminary considerations and the goals and the important concepts? So I'll take you through the 6 essential drafting elements. Number 1 being the scope of the arbitration clause. Secondly, ad hoc or institutional arbitration. Then third, seat of arbitration. Fourth, governing law of the arbitration clause. The fifth being constitution of the arbitral tribunal. And then lastly, the language of the arbitral proceedings. So I'll just start by giving an example of a basic arbitration clause. A basic clause would read, any dispute, disagreement, controversy, or claim, whether contractual or non-contractual, arising out of or in connection with this agreement, including without limitation the existence, validity, formation, enforceability, performance, or termination of this agreement and of this arbitration clause shall be finally resolved by arbitration under, then you include the rules. So that's an example of the scope. Yeah, I'll dive deep into it. And then we go to the seat. The seat of the arbitration shall be, and then you put the city and then the country. Then the governing law. The governing law of this arbitration clause shall be the substantive law of, and then you include the jurisdiction. Then we go to the number of arbitrators. The number of arbitrators shall be, so you either put 1 or 3. And then last is the language. The language to be used in the arbitral proceeding shall be, and then you put the language. So this is an example of a basic model clause arbitration agreement. There is no such thing as an all-purpose or one-size-fits-all arbitration agreement. So it's essential to consider the appropriateness of each aspect of the arbitration agreement and make the necessary amendments to suit the particular circumstances of each contract. So let's dive deep into the scope of the arbitration clause. So, like I alluded earlier, with the broad definition of dispute, any dispute, disagreement, controversy, or claim, whether contractual or otherwise, arising out of or in connection with this agreement. Here I advise use broad language. Broad language is in connection with or relating to, rather than using narrower language. Narrower language is arising under or arising from. Then we go on and say, so all that shall be finally resolved by arbitration. So this is clear and unmistakable intent to arbitrate when you say shall be finally resolved by arbitration. And so any attempts to limit the scope of the clause can lead to parallel proceedings and inefficiencies. So let's take note of that. Let's have a broad definition of the dispute and not broad language. Let's use broad language. Let's not use broad language in connection with relating to. Let's not use narrower language. Narrower language is arising under or arising from. I hope that's clear in terms of scope. Then we go to ad hoc or institutional arbitration. So I'll just give the characteristics of each. So ad hoc is more flexible, yeah, but there's a risk of delay. Parties are responsible for administrative support, and parties can also use an arbitral institution for certain administrative services without using its arbitral rules. Whereas institutional, the case management and secretarial services they have to be provided for a fee. And you get institutional expertise, for example, arbitrator appointment, and then the institution acts as a buffer between the arbitrators and the parties on issues such as fees. And then, of course, institution can result in an overall smoother process. Yeah. So that is that. Then we move on to the seat of arbitration. So what are the key considerations here when choosing a seat? I think one of the key considerations is friendliness to arbitration. You know, is there party autonomy? Is there judicial assistance or intervention? And then what are the qualities of the local courts? Are they efficient? Are they impartial? Then you also have to consider representation. Is there availability of a specialist counsel? Are there restrictions on counsel and arbitrator's nationality? Yeah, so that's what to consider when choosing the seat. And then number 4, governing law of the arbitration clause. So what is the significance of choosing the governing law? The law governing the arbitration agreement determines its validity and interpretation, among other issues. What are the recent developments here? For example, we have the English law, the Arbitration Act of 2025, that reformed the approach to determining the governing law. So here, what I would advise, best practice, expressly specify the governing law of the arbitration clause, in addition to specifying the governing law of the matrix contract. Yeah. So that's what I would say on governing law. And then we move to constitution of the arbitral tribunal. So here, what to take note of is the number of arbitrators, the appointment mechanism, and then arbitrator characteristics and qualifications. So when we look at number of arbitrators, it's either one or three. And what are the factors to include? Amount in dispute, the nature of contract, and the complexity of the potential disputes. And as for appointment mechanism, I advise that you check for the mechanism in the applicable arbitral rules. And then for arbitrator characteristics and qualifications, um, this is an optional provision, but it must be drafted carefully and it must be clear, yeah, because it's a potential for satellite disputes. Then the last key element when drafting a clause is the language of the arbitral proceedings. What are the factors to consider when selecting the language? The language of the contract, documentary evidence, witnesses, experts. You might have experts that are not familiar. Whatever you have French experts, you can't just conclude that the language will be English. And then also in-house lawyers and external counsel, and then of course costs, all that you have to consider when choosing the language. But then what would be the additional considerations when drafting an arbitration clause? Confidentiality is something you should consider. Interim relief, finality of the arbitral award, and then time limits. The clause should have timelines. So to conclude, I'll just conclude with key drafting do's and don'ts. What I would do, consider what is appropriate for your client's commercial and strategic objectives. Ensure that all of the essential drafting elements are included in your arbitration clause. Consider whether any additional factors need to be addressed in the arbitration clause. Like I had said earlier, you can't just use a model clause. You have to fit it to whatever dispute you're trying to avoid. So what are the don'ts? What I wouldn't do is, again, take a one-size-fits-all approach to drafting an arbitration clause. And then don't overcomplicate the drafting. This could result in satellite disputes. And then don't leave the drafting of the arbitration clause until the last minute. Yeah, what other people might call a midnight clause. And I have examples of arbitration clauses with which are lacking in some elements, but that would mean the participation of the participants. But that's all for me from now. If the moderator can guide, if I can share problematic draft arbitration clauses and see where the drafter went wrong, or the questions can come in the Q&A. But that's all for me. Thank you.
Thank you so much, Edith. I think that will be useful. Maybe you can share one or two. Then if any questions arise from that, now we can address them at the Q&A session.
Okay, so I hope we've been paying attention to how wide the arbitration, the scope of the clause. I have an example here. All disputes, differences, or questions arising out of, first of all, that's a red, let me call it a red flag. We say this is narrow. Saying arising out of is narrow, yeah? We should make it broad, yeah? So arising out of this agreement shall, which by broad I mean in connection or relating, avoid using words like arising out of. So this says all disputes, differences, or questions arising out of this agreement shall be referred to arbitration, yeah, under the rules of arbitration of the ICC in London. Again, what do you mean ICC in London? That doesn't make sense. And then by one arbitrator. So what is missing from this clause? It says by one arbitrator appointed in accordance with the said rule. So the scope of the arbitration clause, which I've already explained, is not clear. You should never use arising out of, that's narrow. Then the identification of the administering arbitral institution. Yeah, you're saying ICC, then you're saying LCIA, you know what I'm meaning. And then the seat is lacking, and then the governing law, and then the language is also lacking from this arbitration clause. Then let me see if I can get another example. So ideally, maybe just correct, just a minute. Another example, again, any dispute arising from the execution and interpretation of this agreement shall in the first instance be settled through conciliation. The parties will reach a timely agreement on the applicable conciliation procedure. In the event of failure of conciliation, the dispute will be submitted to arbitration under ICC rules. Just from the look of it, it's even lacking timelines. Yeah, it's saying conciliation, not timelines. But also what is missing is the state of arbitration, the governing law, and the language. So I think you can see how easy it is to draft a problematic arbitration clause. And I just implore all of us to pay attention to the key elements to avoid drafting bad clauses. Thank you.
Thank you so much, Edith, for opening up the webinar in a very insightful manner. Thank you for reminding us that arbitration clauses are not last-minute projects, that they are things that we should think about from the beginning of our project. And in so doing, we will avoid a lot of inadvertent mistakes that we tend to make when drafting arbitration clauses last minute. Thank you so much. And now we will proceed to the next session, which will be led by Francois Ingabire. As a case manager and capacity building specialist at the Kigali International Arbitration Center, she interacts with arbitration proceedings very often, and she is therefore the right person to tell us how technology has changed arbitration proceedings and how we can leverage digital tools to ensure that we get the best out of ADR and especially arbitration. Francois, take it away.
Thank you so much, Rosalia. So you can pronounce my name as Françoise. Good
Okay, I'll be
afternoon.
practicing as you speak.
Yes, thank you very much. Good afternoon, everyone. Good afternoon, participants and fellow panelists. I have the privilege to talk to you on this insightful topic with mastering arbitration clauses in modern contract, but specifically on technology in arbitration. How can technology be used in arbitration to have an efficient arbitration, also at a low cost? So by starting, I will just cover to provide a hint on tools that are being used as of today and how they're transforming the traditional arbitration to the modern arbitration that we are living in. So when you look at technology, technology is actually transforming every sector, I would say, not only in legal sectors, but finance, education. Everyone knows that technology is now something that we are living in, and it happens each and every day. And, arbitration has been, yes, viewed as efficient, as flexible, but when it comes to, case preparation and also how you argue a case, it has been viewed that at the end of the day, there are still, paper heavy sessions. You have to prepare a lot of sessions with printing, with sending over bundles and bundles, and sometimes they actually miss, and then you have to struggle to go and find which one is missing because maybe you sent an incomplete file and everything. Those are the things that are being dealt with where technology is actually simplifying life of arbitrators, of parties, and lawyers. looking at some of the transformation, for example, the Kigali International Arbitration Center has now launched its e-case management system this year. And it's actually quite interesting when you look at the life that the center used to have and the life that the center is living, because um, filing, communication, and hearings used to be, the hearings used to be physical, the filing used to be physical. You could send bundle of documents. We used to have cases where a party had to send like 5 boxes of bundles from shipping from Kenya to Rwanda. You can imagine how much time they spent in the customs and everything. But as soon as the center initiated the e-case management system, life has never been the same, I would say, because now parties are filing electronically, and they can track their progress of the case. They can also access the documents, each and every document that has been sent. And also they receive notifications of their case at every stage. And also, as the parties receive the notification and everything, the arbitrators also can track the case, they can communicate, and also the center. And you can imagine how it has shifted and how much life is now easier, I would say. And the transparency it is bringing, because everyone is using the technology. And also it has cut the cost to an extent. Imagine having a case. We had a case here where one party was in Rwanda, another one was in Kenya, and then the tribunal was composed of 3 members. One was in Singapore, another one was in Malaysia, and another one was in Nigeria, I think. And imagine that cost of traveling just to come and have a hearing, when you can file everything and also have a virtual hearing. It's I would say it's cutting cost, and which is a good thing to parties, and it is making life easier to arbitrators and to lawyers as well. And it is bringing confidence in investors. When you have that efficient, transparent, and fair system, you trust in the system, and you are free to use the system. Talking about the e-case management, the key e-case management system, there are also some of the global developments. Like the ICC has what they call Case Connect platform, where you can actually file your case, and also the collaboration between the parties. And I think also the Singapore International Arbitration Center also has something like that. And in Africa, I think IAC is the first arbitration institution to bring that kind of system. And I believe all the institutions and other arbitration practitioners will create also something. Also, when we talk about technology, we cannot ignore virtual hearings that are now taking place. And when a virtual hearing is happening, because after the pandemic, we've been now using virtual hearings, because it started in the pandemic, and everyone had no choice other than using the platform that are in place to have hearings, because at the end of the day, work will not stop. And after that, it's actually like something that was like a trigger to to show people that you can actually have your hearings without moving or without traveling a lot. And we've had so many cases, and that have happened where arbitrators would sit in every place they win, and then they could conduct a hearing. We've had witnesses, testify remotely, and award were given in a timely manner. So we do not have any concern about that, as long as parties have agreed on the same, and also the arbitrators, everyone involved in the case. Also, going forward, we cannot ignore some of the AI-driven platforms that are being used by lawyers, by parties, by arbitrators. For example, there are what is called Nextlaw, which helps in analysis of documents, and also use Mundi, which provides a AI-driven platform on research. There are so many that I cannot name now, but all they do is that they help in document review, research. Some of them provide, a timetable. Some of them also provide the services of transcription. So it's a lot of services and things that are being provided by these platforms, and the work has been easy for those who use technology, because we used to think that technology is for young people, but I believe everyone here is now agreeing with me that technology is for everyone, and we are not living in future as we used to say. We are here with it and we are living with it. So we cannot talk about those platforms without mentioning some of the, I would say, challenges or risks that come with them. But even though they are there, every opportunity comes with a risk. So it is for us to manage, if I'm going to use technology, to what extent I'm going to use it. For example, these tools sometimes create like worries of inaccurate feedback. For example, there is a case in New York where lawyers used ChatGPT, and the ChatGPT gave them a wrong case, and they used it as a case law, and it was fake. It did not exist. And they used it as a case law, and the arbitrators, when they found out, they were fined. But when everything that is put in the system, I would say it's in computers. Like, there is no human judgment, there's no human nature to agree which one is better, which one is good. So it is up to us who are using these technologies to know, to do our own research as human beings, and not be controlled by these platforms. And also the security is also sometimes an issue, and also sometimes infrastructure to use those platforms. But there are some of, like the Chartered Institute of Arbitrators has now issued guidelines on the use of AI in arbitration. And it's like a call: yes, you can use the AI, or yes, you can use technology, but have some limit. Use them to this limit. They provide limitation to the use of the AI or the technology, and also it provides like a list of things to consider when you're considering to use a technology in arbitration. So looking at those platforms and then the risk, one would ask, like, what can we do to embrace technology, but also to not forget that we are humans, and also we are dealing with computers. So we can say that, as we said, as the first presenter said, she mentioned that, the arbitration clause are called midnight clause because they come at the end. And yet they decide who is going to hear our case. They decide where the case is going to be heard, and how the process will run. And, it's enforceability. So you would ask yourself how maybe you can embrace technology in the arbitration clause, but also not forgetting, what needed to be done. For example, you can draft, your clause and then put explicitly the use of electronic communication, the use of digital platforms, and also to have limits that you have to always confirm that the human oversight remains, central. And by choosing, the seat, also look at the seat that you're choosing, and does it embrace technology? And is my word going to be forced if I use technology? Did like my seat that I chose, does it, go with the technology that is, being used at the seat of the arbitration? And also, in terms of institution, I would say that, institutions should ensure that their platforms are secure, and they should also train the users, because sometimes you can have a platform, but if the user are not trained, and then at the end of the day you're not using it. And also, make the platform known, make the platform, out there, put it out there, and then make it known. So to conclude, I would say that, as I said earlier, technology is here and we are not going to dodge it, but we should learn how to embrace it. We should learn how to work to deal with it, but without forgetting that we also, the human judgment is very important. They make our work easier, they make our work faster, but again, those are computers, those are machines. We are needed as human beings, to know to what extent to use the technology. And I would urge everyone, to use technology, because yes, technology can never replace lawyers. It can never replace, arbitrators. But I'm sure, the arbitrators who do not use the technology, or lawyers who are not going to use technology, will be replaced by those who do. Yeah, thank you. That was it for me.
Thank you, Francois. Thank you for the reminder that lawyers who do not use technology will be replaced by those who do, but not those who quote the wrong case law, I'm sure. Thank you so much. For those who have just joined us, that was session 2 out of 5, led by the incredible Francois Nkabire. And she has confirmed to us that technology is not an enemy of effective dispute resolution. In fact, it can be used as a partner to us who are in the dispute resolution field, but we also have to be careful because it has a lot of pitfalls that we need to avoid if it is to help us advance our dispute resolution causes. Thank you so much for joining us, and thank you for keeping the questions flowing. I can see a few questions on the chat box, which our panelists will address at the end. Cynthia Kavu would like to know whether it is able to share on the screen the problematic clauses that she was talking about. Wanza Mavuti is asking why is arising out of narrow, while I understand it to mean all matters that are connected with the agreement, which might also include other subcontracts that use the contract address mother contract and specifically cite it. So Idris, I think those two are directed at you. You can just note them down, address them at the end. Then there's another one directed at Francois. How do you ensure data protection, privacy, and confidentiality with issues of hacking? So you can note that down to address it at the end. Meanwhile, please keep the questions coming, keep the comments coming. We now move to session 3 out of 5. And the question that Oscar Gadura will be answering is, how do we ensure that the arbitration clauses we draft are not just pretty on paper, but they can be enforced? How do we ensure enforceability, cross-border enforceability? How do we ensure that we are able to navigate public policy limits and procedural safeguards, even as we draft dispute resolution clauses, which the two earlier speakers have emphasized that are very important and are not by the ways or afterthoughts. So Oscar, please proceed.
Thank you, Rosalia, and good afternoon to you all. I hope I'm audible.
Yes, you are, Oscar.
Great. Then we can move ahead with addressing the issue of drafting enforceable arbitral agreements. With me here is a presentation that I'll be making. I hope you can all see my screen.
Yes, Oscar, we can see the screen.
So first we need to address why do we need these arbitral clauses? As you may all understand, unless this clause is in writing, then it cannot be enforceable. That's why we first adopt the writing way. This writing can be incorporated in a contract or even through post-contractual negotiations through, for example, email communications or even letters. Now, when you are drafting a clause, what will you look at? First, you need to embrace a jurisdiction which subscribes to the New York Convention, because that way you get cross-border leeway to enforce awards. The New York Convention, it's for recognition for all states that have ratified the New York Convention. You can enforce an arbitral award as you would enforce a judgment in that same jurisdiction. You also need to look at the divergence of the parties. In this case, you can, for example, when you are dealing with Kenyan, Tanzanian parties contracting, you can now go to Rwanda for the arbitral process. We also need to look at how well we focus on the mantra of the dispute that arbitration will address. This one has been settled, especially in our Kenyan case in Nito Agrovet versus Airtel, where our Supreme Court is profound in saying that where a tribunal goes outside the scope of the arbitral agreement, then that same determination can be set aside. The case also opens up issues of appeal in our arbitral awards, especially where there is a large miscarriage of justice, and therefore in Kenya we can fairly say that arbitral awards can be appealed as long as parties can prove a lot of miscarriage of justice. Then let me go to the gold standard structure of a modern clause, which my colleague Edith did very well. And as you can see, this is it. It has to cover the scope, the seat, the institution, and the rules, the law of the arbitral agreement, the tribunal, the language, the interim measures, and issues of consolidation and confidentiality. This is what Edith was alluding to when she first presented on how well to draft a clause. But then we need to appreciate that our arbitral institutions, for example, Kigali Center for International Arbitration, and in our case, Nairobi Center for International Arbitration, it's Kigali International Arbitration Center. These organizations have have given parties some guidelines on how well they can have their disputes determined under their institutional rules. So then they publish from time to time clauses which parties can adopt in their contractual negotiations. But then they also open up to post-contractual negotiations where once parties agree that the dispute can be decided in either of these institutions, then they can move to those institutions. I also need to emphasize, for example, in our Kenyan case, in our East African case, we have some East African states who are not members of the New York Convention. Could be South Sudan, for example. So if you are drafting your clause, it's not advised that you will. You remember, the tail end of the arbitral proceedings, you'll need to enforce these awards. So there is need for you to go for a jurisdiction where one, those courts are friendly to arbitration, and two, where those same jurisdictions are or have ratified the New York Convention. Now, what do we need to have in mind when you are drawing an arbitration clause? In the course of my practice, I've seen people saying, for example, say arbitrator A is the one who will decide the dispute. But then we are all mortals, and you wonder whether they are aware that by the time that dispute arises in the 6th or 7th year of the contract, then that arbitrator will be alive. Then you have a challenge in appointment. So we need to have the future in mind and also determine the scope of the disputes. Like Edith alluded to, yes, having a broader a broader spectrum is better rather than a narrow one. There is always the issue of costs, which are informed by the number of arbitrators. In our case, for example, you can have our 1 Kenya shillings, 1 million dispute, but then you are saying there that your tribunal will have 3 arbitrators. So you'll find your costs getting to around 30% of the dispute, which is quite unfriendly in commercial terms. So it's for you to look at the scope of the dispute, the scope of the contract. What is the contract? What is the subject of the contract? Then from that, you can now have the leeway to determine the size of your tribunal. In normal terms, you will find disputes that are of low value having just a single arbitrator. And even you will find most institutional rules, for example, those of NCIA, you will find them saying that unless parties agree otherwise, the arbitrator is just a sole arbitrator. So then this is meant to bring some commercial effectiveness and commercial sense into resolving disputes so that it's not as expensive. So even in your contractual negotiations at the drafting stage, you need to have such things in mind. I'll point out some 3 strategies for the audience today in which you can use to craft an enforceable arbitral agreement. This one would first do some research around institutions, do some research around their rules, and also around their jurisdictions, and also the courts, because the courts will always assist you in enforcement. I would go away from comparing institutional versus ad hoc arbitration, but then I would advise for institutional arbitration. In this sense, institutional arbitration, you'll first get technical advice, and second, you have some control as a party. Where there is a gap, the institutional rules will always fill that gap because they have a way they have foreseen such kind of gap and provided for it. I'll give an example of, for example, if you go to the Nairobi Center for International Arbitration Rules under Rule 7 in the appointment, parties are first allowed to agree on an arbitrator. If there is no agreement on by the parties on the arbitrator, then the registrar appoints within 30 days. You see, in that case, you have an expectation of when, how, and by who the arbitrator will be appointed. The second strategy we need to have is to ensure now enforceability by first addressing only matters within the public policy of the jurisdiction in which you are. For example, I would give one, for example, an agreement for supply of drugs. Even though such an agreement has an arbitral agreement within it or an arbitral clause, it cannot be enforced because the end of the contract is illegal in nature, so it cannot be enforced. So it's for you also to make sure that the scope of the disputes are also within the public policy. It's also desired that you go for people, you take advantage of industry experience. For example, say you are dealing with company A and B, dealing in cotton. So ideally, you would put there in your contract that your arbitrator should be an expert in the industry practices of cotton ginnery and textiles. So that way, you'll have somebody who understands the industry. You'll see much of this in maritime disputes where the contract will read that those desired arbitrators must understand the customs, practices, and the law of maritime transactions or the maritime industry. We also need to understand that arbitral agreements are separable from the entire whole, in the sense that whereas we would have an entire agreement, that arbitral clause will remain independent of the entire agreement. Even if you were to nullify the entire agreement, then that arbitral clause will remain independent of the nullification. And lastly, how will we maximize the benefits of arbitration? First, we need to understand confidentiality in the sense that we need to only allow those people who are affected, those people who have the authority to deal with the arbitration. We also need to guard our reputations as businesses and also some intellectual property matters and trade secrets. We also need to, like alluded to earlier, on the issue of costs in relation to the tribunal. In many arbitration proceedings, you'll find the arbitrators or parties calling for capping of costs, so that the arbitration procedure, by the very end, it does not go to insane amounts where it does not make commercial sense. So right from the start, at the time of drafting, you control it by having a lean tribunal in odd numbers, either 1, 3, 5. Then during the proceedings, you would even make an application to have the costs capped, so that then whoever goes away with the costs, then or whoever is awarded costs does not injure the other party so much that they don't receive the commercial sense. You would find an arbitration where the subject matter versus the costs. The costs are 50% of the subject matter. So then that would be commercially ineffective. We also need to address issues of timelines, and this is where now the institutional arbitration beats ad hoc arbitration by providing timelines within which what should be done, by when, by who, and also at the same time embracing issues of party autonomy, such that unless parties agree otherwise, then the arbitrator is allowed as a master of procedure to guide parties. The last one would be on finality of awards. It has been a debate here in Kenya on how final awards are. People feel awards are final, arbitral awards are final, and an aggrieved party does not have any recourse. But then through the new to aggravate case, then in Kenya, I can fairly say that there are limited grounds of appeal on awards, especially where there is a massive violation of the of procedural justice. So this is a brief checklist of what you can check in terms of when you have already come up with the award, also with the arbitration agreement. This is what you need to maybe pass through and see whether your clause meets these standards. I believe Rosalia did point, our moderator pointed out that the Q&A will be at the end, and I'll be happy to hear from you. Thank you for the opportunity.
Thank you so much, Oscar, for that reminder that we have to have the end in mind, even when we're drafting arbitration clauses, and we have to think of whether any award that comes out of an arbitration proceedings arising from the contract we are drafting can be enforced. Thank you so much for that. And I take this opportunity once again to welcome those who have just joined us. That was session 3 out of 5, and we have been reminded that we shouldn't focus on the arbitration clause being flowery on the paper, but we should also conduct research and do as much as we can to ensure that it can be enforced. Thank you so much, Oscar, for that. I can see more questions have been posted on the chat. We will address all of this at the Q&A session. For now, allow me to introduce our second last speaker, that is Peter FCAB. Peter will tell us whether we are ready for the emerging sectors that are coming up, fintech, e-commerce, what have you. Are we ready? What do we need to make sure that our arbitration clauses still make sense in the wake of the new sectors? And having been in this legal practice sector for more than 14 years, I'm sure he has seen the transition into these new sectors from the traditional sectors, and he will help us unpack how to leverage on this and make our resolution efforts better. Karibu sana, Peter.
Thank you very much, Rosalie. I hope you can hear me. Please confirm.
Loud and clear.
Yes. I think I'll ask Oscar to cancel his screen share to enable me share. Thank you very much, Oscar. Thank you for this opportunity, and thanks to everyone who has joined. I want to dive straight into it. I'll just share my PowerPoint. So today I've been asked to talk about arbitration in the new sectors, fintech, primarily fintech and renewable energy. And I hope to share practical insights from my experiences, both counsel and arbitrator, having handled arbitration and litigation in diverse sectors, but also today focusing primarily on arbitrations on fintech and renewable energy. These are two very fast growing sectors in this part of the world, East Africa. And I hope by the end of this presentation, we'll be able to understand what they mean for practitioners, especially for us East Africa practitioners, so that we can be able to draft and use arbitration clauses more effectively. To begin, we'll first look at why fintech and renewable energies are generating new kinds of disputes. And then we'll also consider why arbitration is often the preferred tool to handle those disputes. And we'll then look at the global and East African trends. And finally, I'll try and share practical tips for drafting effective clauses in this new, specifically for these new sectors, so that we ensure that our clauses are flexible but yet enforceable. To begin with, according to statistics throughout the world and specifically East Africa, we are told that East Africa is experiencing a boom in fintech and renewable energy. For fintech, we have a lot of growth in mobile money, digital payment platforms such as M-Pesa, PesaPal, etc., which have become household names. And for renewable energy, we have various wind.
Peter, we seem to have lost you.
Can you hear me now?
Yes, we can hear you now.
Okay, sorry about that. So I was saying that East Africa is experiencing a boom in fintech and renewable energy. And the two sectors that stand out are fintech and renewable energy. For fintech, we have a lot of growth in mobile money and digital payment platforms such as M-Pesa, PesaPal, and Flutterwave, for example. And in renewable energy, we have things such as wind farms that are coming up. We have solar parks in Uganda and across the East African countries. Of course, these new sectors come with innovative business models, and sometimes they are presenting untested legal issues. We are seeing major investments, for example, international funds coming in to finance companies in these sectors. And with there's tremendous growth in these two sectors. And of course, with this growth, naturally, disputes will arise. Some of the disputes that we've experienced and encountered relate to, for example, disputes relating to infrastructure delays, regulatory changes, or partnership breakups. Many of these deals involve parties from multiple countries. For example, you might find a Kenyan company who has gotten a foreign investor. And therefore, with these multiple parties from multiple countries, making a neutral dispute resolution mechanism or provision for it becomes crucial. In my view, the stage is now set for arbitration to play a very big role, and that's where we come in as practitioners, both as counsel and as arbitrators. I'll move on to the next slide. So why do I think arbitration works for fintech and energy? The first thing that I've seen that's making arbitration attractive is cross-border enforcement. As we've already stated above, these deals, most of these deals involve international parties or operations in multiple countries. With arbitration, you can choose a neutral seat and rely on the New York Convention on Enforcement of Arbitral Awards. For example, if, for example, a fintech startup that is partnering with a foreign operator, they would need assurance that any award can be enforced beyond one country's courts. I've seen especially foreign investors insisting that they don't want to resolve their disputes in the domestic courts. And that's where arbitration comes in. And for your information, most East African countries, including Kenya, Tanzania, and Uganda, are signatories to the New York Convention. And therefore, we should be able to advise our clients to have it as included in the dispute resolution clauses. One other advantages or reason as to why parties should consider arbitration for these kind of disputes is because for arbitration, we are able to handpick arbitrators who know the field. If, for example, you have a complex software licensing dispute or maybe a solar plant construction claim, you might be able to select someone with vast in IT law or energy contract. Of course, that expertise can lead to more informed, faster decisions than you would have gotten where parties litigate in a commercial court, where it's just a judge with very general knowledge on these sectors presiding. Of course, the process is also flexible. Parties are at liberty to stipulate the technical experts they want to use in the event there's a dispute. You can also stipulate the rules that you want to apply in the resolution of the dispute. And in some instances, I've seen parties even split a dispute in phases to help manage the dispute and resolve it a bit faster. Another advantage and a selling point for arbitration is confidentiality. In my experience, and I'm sure many of us share that, fintech innovations and energy projects data are valuable and sensitive, and arbitration proceedings are private in nature. I think one of my earlier presenters has pointed that. And keeping trade secrets or critical project details confidential becomes paramount. As opposed to court processes where the records are public, for arbitration, proceedings are private and only the parties and the arbitrator become privy to them. This is a good selling point for tech companies in particular because they value privacy for their commercial dealings. Another selling point for arbitration is the speed and adaptability. Of course, in the fintech world, things move very fast, and parties would want any dispute that arises to be resolved as quickly as possible. And in my experience and view is that if arbitration is managed well, it can be faster than having to wait for years on end, caught up in the court systems, especially in Kenya, where litigation can drag on for years. So if you manage your arbitration well, parties can agree to, for example, expedited hearings. You can have online hearings. In fact, in some instances and jurisdiction, I've seen online dispute resolution and other tech tools making arbitration more efficient. I don't know if one of the presenters is going to talk about some of those tools that have been developed in the recent past to help manage arbitrations. Of course, people in tech and energy, and especially tech, are very comfortable with adopting technology to resolve their dispute. So that shouldn't be a problem in terms of the uptake. Another major selling point for arbitrations where clauses are worded properly and drafted effectively, you can have very minimal court interference. This is especially important in jurisdictions where court processes are slow and outcomes uncertain. Anyone who is very keen currently within the Kenyan jurisdiction, you'll realize that there's a lot of noise in our courts, noise about corruption and incompetence and what have you. So if you recommend arbitration, I think that is one point that you might highlight for the parties to ensure that you have control over instances in which the courts can intervene. And of course, this issue has also been resolved up to the Supreme Court, and the courts are quite ready and willing to enforce the arbitral clauses. In short, I think arbitration provides a tailored and reliable mechanism that aligns well in the cross-border and technical nature of fintech and renewable energy transactions. To move to the next slide. So then I want to consider what fintech arbitration trends are there in the world based from my experience and research from various jurisdictions. I think we are seeing a surge in digital economy disputes. Digital economy, crypto exchanges, payment processes, e-commerce platforms. When things go wrong, for example, there are failed partnership, there's regulatory clampdowns and what have you, many parties are opting for arbitration. And globally speaking, arbitration is being tested because there hasn't been a lot of litigation for most of these emerging areas. For instance, of course, now with the new cases and disputes, new issues arise. For instance, in cases about cryptocurrency agreements, questions have arisen on jurisdiction and arbitrability, since digital assets, as you know, often have no clear home jurisdiction. So those are some of the issues that you must be very keen when you're recommending arbitration in these contracts. Of course, the world is not seated. It's reacting to some of these challenges. And I'm aware that in the UK, for example, we have the Digital Dispute Resolution Rules 2021. These are available online, and anyone interested can look for them and try and see what areas they're trying to regulate. Some of these rules can be written directly into the smart contracts and the blockchain contracts and blockchain codes and what have you. Most of these rules allow for automatic dispute resolution or expert determination. Of course, this is a new, I don't think we've had that here in Kenya, and East Africa generally, but that's the direction in which the world is moving. Of course, while there is no major arbitral institution that has its own crypto-specific rules, I think for fintech practitioners and energy practitioners, these innovations are influencing contract drafting, and you must have that at the back of your mind. One other area that is growing traction is the online dispute resolution, which gained traction post 2020, the COVID. Nowadays, it's not unusual for entire arbitrations to be run online. In fact, I have seen certain experiments being done, for example, in the UK, where arbitrations are being conducted fully on metaverse. And this is a mind-blowing technology, and it's just a matter of time before we also get into it. I think we might be following, but we'll get there. Of course, there's a big question on the enforceability of such awards. Enforcement under the New York Convention could be tricky due to if due process is questionable. However, I think I've seen traditional institutions such as the ICC, LCIA, upgrading their tech capabilities. A colleague from Kigali has also said Kigali International Center for Arbitration is also adopting technology, and every institution is trying to adopt technology. Even in Kenya, I think the NCIA and the Chartered Institute are doing a lot of training on this new tech that is coming in place. Another trend that is coming up is, of course, the AI involvement in dispute resolution. There's a lot of people have started picking up AI, and of course, it's not deciding cases on behalf of parties, but AI has been employed to automate some of the tasks. For example, AI can help you review documents, can transcribe. I think like this session is being transcribed. That is part of AI. I've seen in the US, the Silicon Valley Arbitration and Mediation Center has recently published draft guidelines on using AI in arbitration. I can share a copy of that, whoever is interested. So this means, in my view, that future fintech dispute might see AI helping streamline the proceedings, which will of course go into lowering the time, which also translates to cost savings. Overall, in my view, the global trend in tech dispute is clear. Arbitration is adapting and remains attractive for digital disputes, but it's evolving through new rules and tech tools, and we must try to keep up by doing trainings and reading and just making sure that we are open to what is happening in the rest of the world. I'll now quickly turn to arbitration in renewable energy. I'll not take so much time on this. Of course, it's one other sector where arbitration has become indispensable. We have seen seems to be a global push for green energy that is leading to huge investments, and with them, of course, comes disputes. In Kenya, there's a lot of push for relating to some of these projects. And according to statistics I found from some website, the world is investing nearly twice as much in renewable energy as opposed to traditional oil and gas. In as much as may not verify that, I think I agree to some extent based on what we've seen even here in Kenya and across East Africa. There's a lot of focus on renewable energy, that is solar, wind, and other types of renewable energy. Of course, this increase in investment means that there are more projects. The more projects there are more contracts, there are more engagements, which means that we're likely to see more disputes. And arbitration is reflecting this shift. We have seen an increasing percentage of arbitration cases coming from renewable projects. In fact, within international arbitration institutions such as EXID, which is basically for investor-state disputes, renewable cases such as solar farms, wind farms, hydro projects have been on the rise over the past few years. Some of these disputes that I've seen and I've experienced and I've been lucky to assist in resolving include contract disputes for power purchase agreements. There's one that we were doing involving a solar plant and a government off-taker. It's currently undergoing arbitration. Other disputes that I've seen cropping up dispute relating to regulatory and policy changes. Sometimes you find a government comes in place and they put in place the regulations and policy changes that impact the existing project. Of course, that's also another cause for dispute. But I've seen with innovative drafting, you can sort of lock some of these things. But maybe that's a story for another day or a different seminar. In East Africa, if I would come back home in East Africa, we have had some notable cases which you can look up and read. For example, in Kenya, we had an exit case by a Canadian-American company that is called Walam Energy. It's one of the cases that is available online. When Kenya revoked a geothermal license at Suswa. The arbitration was concluded in the year 2020 and Kenya won. Of course, this goes to show us that even dispute over renewable resources are being handled in international arbitration. And in my experience, even for international arbitration, there's no special skill that is required. If you're a diligent practitioner, you can learn some of the rules that are applied in this arbitration, and you will be able to actively participate and maybe grow that area of practice. And to see whether there's another example I can give. Yes, the Lake Turkana wind power project. During its implementation, there were disputes over delays in building transmission lines, which led to arbitration claims for compensation. The government has had to pay penalties for delay in the grid connection. Of course, all this went to arbitration. There are Kenyan lawyers that are involved. There are Kenyan arbitrators that are involved. Even where there are international arbitrations, we've seen Kenyan arbitrators being involved. So there's no reason as to why these opportunities cannot be accessed by members of the East Africa Law Society. We just need to be vigilant, get training on it, and just position ourselves properly so that we're able to tap into these opportunities. I'm also aware that Tanzania and Ethiopia have also encountered some of these issues. And what I've seen that is common in some of these contracts is that virtually all those contracts have arbitration clauses, often referring to ICC arbitration or the ancestral model. The ancestral model is what we have in Kenya that was domesticated under the Kenyan Arbitration Act. So it's nothing new. You may get a query on it. In fact, how I found out was after I got a query from a client who asked me whether I'd done anything like that. And then I realized that it's the same thing that we do here, only that the names are different. So it's something that we can do without even extra training. So one thing that you need to be considerate about for some of these energy-related arbitrations is that they involve multiple parties. You'll find an arbitration as a government entity, or rather a project has a government entity. There's a project company, you have contractors, you might have subcontractors and financiers. So when you're drafting the clauses, you need to consider and make provision for joinder or consolidation of any dispute that might arise involving any of these parties that are undertaking the project. Because if you don't do that, you're likely to have parallel proceedings for the same project. So if you have a poorly aligned dispute resolution clause, then you might end up having fragmented fights all over the place, which can then be very costly for the parties involved. I've also seen that these arbitrations use really rely heavily on the expert evidence. For construction disputes, we find a lot of engineers that come in as experts, both as witnesses and as arbitrators. That means arbitrators with sector knowledge are valued, architects, engineers, QSs, and the likes. But even for all these arbitrations, they always, more often than not, insist that they need to have a lawyer on the arbitral panel. So there are opportunities for lawyers, not just these experts that I've mentioned. The other issue that you need to be aware of, specifically for energy projects, is the community and the environmental aspect. While the arbitration is between the contract parties, renewable energy projects can affect local communities. Though community interests aren't directly represented in an arbitration, you will find that their impact might surface. For example, a tribunal might hear evidence about community protest causing delays. It's not the main issue here, but if it will have a background dynamic. And outside the arbitration, those community issues may be in local courts or negotiations. So you might be tied in an arbitration, but you're also fighting other interests outside. Another last issue that I need to point out is the issue of investor state versus commercial arbitration. If you are advising a private company investing in renewables, you need to consider both the contract's arbitration clause and whether there's a treaty arbitration route that exists. Many East African countries have investment treaties that can cover energy investments, giving the investor an exit option if maybe things go south with the state. In my view, that's an extra layer of protection and leverage in negotiation. So if you're acting for such a company, you need to probably make an alternative provision for that if domestic arbitration fails. So then how do we draft effective clauses for these new sectors? That's what I'll cover as I come to a conclusion. The first thing that you need to know is that you need to be clear and comprehensive. Clarity is non-negotiable. If you have a very vague or poorly drafted clause, it will lead to costly detours. For example, you'll find a party trying to move to court to have the court decide whether a dispute is arbitrable, primarily because the clause was poorly drafted. You need to define the scope of the arbitrable dispute precisely. For example, in a fintech contract, you might have to state that any dispute arising out of or relating to this agreement, including existence, validity, or termination, shall be referred to arbitration. If you want to exclude other things, say an issue that must go to a regulator, you can spell that out. When I was preparing for this, I saw a case, one case in Uganda, that is Talu Oil versus Heritage Uganda, where a vaguely drafted clause led to a very lengthy jurisdictional fight that delayed the proceedings. Again, this can be avoided if you put a very clear and comprehensive arbitration clause. The other key aspect that you need to consider is the seat and the governing law. The seat determines the legal framework for the arbitration and which court can intervene. Choose a seat that is well known for supporting arbitration. For example, London, Paris, Nairobi, I think Kigali, they're also very good. Nairobi now has a very good arbitration act that is aligned to the ancestral model law. And a neutral seat is vital where parties are from different countries. Also ensure that the governing law is appropriate. Sometimes the law of the contract might not be the same as the seat. For fintech deals, consider if the law has any peculiarities regarding electronic transactions or arbitration for consumer claims, which I've seen also impacting some of these proceedings. For energy, consider if the governing law covers sector regulation. You may even see stabilization clauses. These are clauses that lock the law. For example, as of the time you enter the contract, you say that the law that will be applicable is the law applicable as at that date, so that any subsequent changes in law have no impact in the performance and the enforcement of that contract. You also need to specify the arbitrator qualification. I've seen most lawyers, when they are drafting these clauses, they never specify what sort of expertise you want. For example, you can require that arbitrators must have certain expertise, e.g. 10 years experience in IT law, or be an engineer with arbitration experience, etc. Then another practical consideration that you could put in place is you can try and make it a multi-tier, you can create a multi-tier dispute resolution mechanism, especially where the projects are still ongoing, which I've seen very common in fintech joint ventures. It is wise to include a step-by-step dispute resolution. For example, you can have the parties negotiate first, then maybe mediate, then move to arbitration. This can save business relationship and resolve issues faster. For example, a fintech service outage dispute might be resolved by the executive just meeting for within 7 days and resolving the issue, as opposed now to commencing arbitration right away. And then you also need to make provision for flexibility and technology. Not dive into that. And finally, you need to ensure that your clauses can be enforced. All the innovation in the clause means nothing if the clause itself is unenforceable. So that if it's ambiguous and it's unenforceable, then you've done nothing. So you need to draft it properly and ensuring that it's something that can be enforced in whatever code that you choose for enforcement. In summary, think ahead when drafting the clause, tailor it to the transaction needs and the sector needs. A well-drafted clause, I normally say a well-drafted clause is like insurance. You hope not to use it, but if you do, it should operate smoothly to get a dispute resolved efficiently. Thank you. That's all. I've tried to rush. I think I realized it was a lot more than I thought. And I can share the slides for those interested. Maybe I write up later. Rosalia, that's all from me.
Thank you so much, Peter. It seems like you have read the minds of many attendees who are asking for the slides. Thank you so much for that very wonderful presentation. Anita, I can see your comment that you're just joining in. Karibu sana. This was session 4 out of 5, and that was Peter, FCAB, just reminding us that arbitration as a mode of dispute resolution is indeed working in the innovation-driven sectors. And it is actually desirable because parties can choose arbitrators who have the expertise that is needed to deal with their respective disputes. Thank you so much, Peter, and thank you to everybody who is interacting with the panelists and dropping questions at the Q&A session. I can see some of the panelists are already responding to the questions. Thank you so much. For the ones that will not have been responded to at the end of our next session, we will ensure to answer them at the Q&A session. Alexandra Muhaya was asking whether the recorded session will be available to watch later. This is proceeding on YouTube. It is live on YouTube, and it will be available on the ELS YouTube platform afterwards for you to watch and for you to share with your colleagues. Moving on to the last but not the least session, led by Catherine Karaoke. Now we are going to the field and we are looking at how we can use practical methods to draft arbitration clauses that make sense, arbitration clauses that can last throughout the life of a dispute, and arbitration clauses that are effective and enforceable. So thank you, Catherine, and Karibu.
Thank you very much, Rosalia, and good afternoon, everybody. Thank you to my previous panelists, Peter, Oscar, Francois, and Edith. And since I'm the last to present, I know my job is to stand between everybody and the Q&A session, so I promise to keep this brief and to the point. Let me start by mentioning something that happened yesterday. Yesterday, a fellow lawyer called me and asked me, did you move to dispute resolution? And are you now in arbitration? And I asked why. And they said, oh, I just saw a poster by ELS, you're participating in an arbitration panel.
And my question to him, first of all, was to clarify that indeed I'm still a corporate and commercial lawyer in the fintech field. But what I asked him is, what is in all the contracts that we draft? Isn't there a dispute resolution clause always? And he said to me, yeah, but they come to think of it, yes, there's always a dispute resolution angle to every contract that's drafted. And I said, that's exactly why. As much as there are those who end up on the other spectrum where they handle the dispute when the dispute arises, most of the times the whole process starts with the drafting process. So to the litigators and the dispute resolution lawyers in the house, I come in peace. And I'd like to confirm that I'm a corporate and commercial lawyer. My name is Catherine Kariuki Mulika. I am a partner at Cavendrees Advocates, and Cavendrees is a specialist law firm that focuses on tech, telecoms, data, fintech, and IP and innovation, that fast moving world that the other speakers alluded to. And my world is really on the front end of deals, and that is drafting and negotiating contracts. And I work or support clients in this highly technical and regulated sector. And here things move fast, and there are multiple partnerships, integrations. There are so many moving parts, and all of them meet in the middle through the contracting processes. And I also happen to operate in a field where many businesses have what we'd call a high risk appetite, and therefore most of the times they will pressure lawyers to just, get the deal signed, get the deal done until later on when, things happen and they find out that, oops, now we have a dispute. And, if you think about it, let me also confess as a corporate lawyer, sometimes we treat dispute resolution clauses like sort of like garnish on a plate. It's there, but we don't pay much attention to it because we're very focused on the commercial terms, the numbers, it's the IP rights, it's the regulatory approvals or licenses, all the things that feel like immediate needs. And that dispute resolution clause then often gets probably copied and pasted from maybe the last deal or the last transaction that you had, really without much thought. But then you realize later, for those of us who've practiced long enough, you hang around or stay around enough to realize that later when things go wrong, that little clause at the back of the contract then suddenly becomes the most important one in the entire agreement. And it can decide whether a dispute is solved quickly and fairly, and whether it turns into years of expense and frustration, as my previous panelists have pointed out. So really, in these short 10 or so minutes, my perspective will be to show that arbitration and escalation clauses are not just boilerplate, but they are really a fundamental part of drafting and negotiations, the whole process, and how they shape the risk profile of the entire transaction. So I'll share practically what I've seen work and what often fails in practice, and some of the pitfalls from a transactional lawyer's perspective, and what we need to watch out for from a very practical and business-oriented angle. So my first maybe thing that I'd like to highlight is really why dispute resolution clauses matter. And I know this has been mentioned and can't be mentioned enough by my previous panelists. But really, as commercial lawyers, we're usually the ones who first come across this dispute resolution pathway or first set it up. And this is when we're drafting the contracts, there'll always be that particular clause that we call the dispute resolution clause. So then we draft it, as I said, long before the dispute arises. And if it's done loosely, then it becomes a pain point later. Because by the time, obviously, disputes come up, then it's too late to fix the clause. So then, we have to consider it. That means that we have to consider it as part of the commercial risk allocation. When we are considering the other clauses that we consider important, the dispute resolution clause also has to be considered as part of the commercial risk allocation. The previous speakers have, talked about how do you determine the seat of arbitration that you're going to recommend and all those things. Then that means you work backward as a corporate commercial lawyer and figure out, okay, what this is the dispute resolution clause is part of the risk allocation, and therefore, what are the considerations that I need to make and make the business decision, and what kind of clause will I end up in? So I think Peter has pointed out about like in the fintech world, where the fintech deals, for example, the investors may insist on international arbitration for neutrality. I've seen situations where mostly, of course, the first port of call, let's say if you are supporting a Kenyan party, the first protocol is probably you'll suggest the seat of arbitration to be in Kenya, but then you'll find that given the nature of most fintech tech deals, you'll find that they are cross-border deals, and the person on the other side will most likely push back. Then you have to know what's your plan B, so that you don't break a deal just because the person on the other side is suggesting that the seat of arbitration be their jurisdiction and yours. You have to know the plan B in terms of suggesting a neutral seat of arbitration that is actually also quite convenient for you. And especially in my field, for the clients that I support, you'll find that even resource-wise, it will be different. You're probably supporting a startup on this other side, and the other side is an established scale-up. And therefore, you'll have to offer very suited advisory on that. And you'll have to consider on a case-by-case basis. So, and in the end, maybe my conclusion to that is that you have to figure out a balance that will be struck at that stage so that the deal doesn't fall through. But then again, your client is protected and both parties feel like it's a win-win. Then I'd like also to highlight on escalation clauses. As Peter pointed out about the escalation clauses, in my field, the tech field, fintech, you'll find that most of the contracts that we draft, they just won't have a straight up arbitration clause, or the dispute resolution clause will most likely have what we call an escalation matrix. The escalation matrix is really it helps on the commercial end of things, so that a small matter doesn't derail the relationship between the parties. So the escalation matrix will look like, it will say the first port of call in case of a dispute. The business teams will try, the business team's point of contact will try and resolve among themselves. And if it's not resolved, then they escalate probably to the CEOs. And then apart from the CEOs, then it will probably be escalated to mediation, and then after mediation, maybe now to arbitration. So almost always in this area, you will always find an escalation matrix where probably it ends up with arbitration or court. And so that's very common, where we don't jump straight to arbitration and a tiered process is set into place. So then again, so the escalation approach makes sense for ongoing relationships. And why this happens a lot is because you'll find there'll be one master contract, but then it will have so many other what I'd call mini contracts revolving around it. So there'll be like a service level agreement or a maintenance agreement. So for instance, like in a software as a service contract or an outsourcing deal, you'll find that parties will have to work together even if they disagree on something. They have an ongoing relationship and they can't really part ways. As I said, so like if it's a software, they'll still need to install updates because you have the license on software. So because of that, they try and work around what we call short negotiation windows and mediation setups to save the relationship. And you'll find that arbitration will be at the tail end of it. Then what I'd like to point out next is on regulatory carve-outs, which is quite common in our sector, because of most of these sectors that I support are what we call in a regulated space. So then you will always have to consider, as you're inserting your dispute resolution clause, on regulatory carve-outs. So this is mostly common in fintech, telecoms. You'll find also in data. You can't contract what we call out of regulation. So, you might have a beautifully drafted arbitration clause, and if, let's say, CBK or DPC or Communications Authority has jurisdiction over that matter, then those matters stay with them. Those kind of matters would only have to be dealt with by the regulators. So then you'll find arbitration. You have to be very clear that arbitration will deal with the commercial disputes, but then regulatory compliance remains with the regulator, and that is always important to point out in your clauses, or to add to your clauses. And the way sometimes I explain to my clients is I tell them, it's like when they ask, like, what's the rationale of that clause that's there? And you have to explain that it's like in football, if the arbitrator is a referee, but the player is caught doping, that goes to the anti-doping authority and not necessarily the referee. And the same thing here, the commercial disputes will go to arbitration, but regulatory issues you have to carve out and say that it stays with the regulator. And actually, like in regulated spaces where we file, the clients are expected to file maybe most of these outsourcing contracts with the regulators like CBK. Those are some of the clauses that they look at, and they just ensure that you've covered that aspect. It always helps. So then what else I'd like to point out quickly, as because I can see most of the things were actually covered by my previous panelists. I'd like to cover maybe the challenge of the seat. I'd like to point out that this comes out a lot. I've seen situations where we advise the client, and the contract, the client was buying a software, and what happened after delivery, after the software was delivered, the client realized a bit later that it wasn't fit for purpose. It's quite technical, but it wasn't fit for purpose. And they tried to go to arbitration as per the contract. But what they realized is that when the contract was negotiated, they had agreed as the seat of arbitration to be in London. And when they did the math, so we were brought in post after this, and we were trying to, look at the dispute resolution angle and everything, but we realized that it was the seat of arbitration was London, and when the client did the mathematics, it just wasn't adding up. It was going to be a very expensive venture, so the client was actually forced to have the CEO fly to, UK, where the supplier was based, and negotiate and compromise on some things. And that is just one example where that proves, in fact, I can't remember which panelist was talking about it, but it hit home to me because I remember that particular case where, again, they had hurriedly gotten into a contract. The supplier had suggested the seat of arbitration to be London, and the client, because they were eager to close the project, they had agreed, and someone hadn't pointed out to the implications or done the risk element of that, or the implications of that in case things went left. And only post the contract, when things went wrong, is when they realized that it was going to be a very expensive venture and just wasn't worth it. And I wanted to point out that idea. And I liked the fact that I think it was Francois who pointed out about how technology is being adopted by most of these institutions, and that should also be considered in this day and age, so that it makes sense cost-wise for your client, and should be a consideration. And I'd also like to point out on the issue of the number of and expertise of arbitrators. I have also seen that happen a lot in my field because of the specialist nature of the transactions or the contracts, or the contracts that we advise on. So then you'll find in the fintech sector, in the tech sector, it's very important, and is usually a very important thing to accompany or to include in the arbitration or the dispute resolution clause that the qualifications of the arbitrator, so that it's very common to see a requirement where that, the arbitrator has to have certain qualifications, that they have to be a software engineer of a certain number of years. I've also seen situations where they carve out very specific that if the nature of dispute has to do with this particular issue, then that's the only situation where we need a specialist arbitrator. And then for the rest, they now leave it to, general a general arbitrator. So I've seen that situation where you can carve out specific dispute and say this one, it has to be an engineer, but for the rest, it can be anybody who's knowledgeable in IT. I find that very interesting, but also very, very, very practical. And also for the tribunal, I know the other thing that we consider, which I think it was Oscar who mentioned that, always consider the cost aspects. Like, do we really need a tribunal? Is it a tech-heavy dispute? Is it also a small sort of like contract, or is it a huge one? Then that determines whether you want a tribunal or you want a single arbitrator. And again, that prevents you from doing the copy and paste and having to think about that dispute resolution clause and thinking about what language you're going to use, so that should the arbitrator just have commercial expertise, or should they have technical expertise relevant to the dispute, or how are you going to go about it? So in part of like painting the pain points that I've seen in our field when it comes to in relationship to arbitration for the innovation sectors, I'd like to point out, there's an element of cost, which I've alluded to. I've seen situations where international arbitration was too expensive for the clients and they really had to compromise, especially for startups. And I've seen situations where also time-wise, which my panelists alluded to, where disputes have taken so long, while in the meantime, technology as usual moves fast. So let's say it was a dispute over a product that had been developed. So then in the meantime, technology has moved very fast, and by the time the award comes out, it might not be relevant, or the product itself might have changed. So that's always a consideration, and that's always one of the things that we advocate when we advocate for what dispute resolution mechanism should be taken up. That's one of the things that we consider, and we advise the clients, given the nature of the particular subject matter of the contract. That's something that we always consider. And then something that's always important for people and the parties will always ask is in terms of enforceability, which again, my panelists have mentioned, because then there are considerations like, if you win an award against a foreign supplier, does it always mean a quick enforcement? And those are some of the considerations that we consider. And then, so what we do is we'll always sit with the dispute resolution teams in our firms, and again, work with them and figure out what is the best clause to have in these contracts. I wanted to point out the pre-contract, which many people don't talk about, the pre-contract and the pilot phase disputes. It's very common in this innovation world to have situations where parties are doing something before they sign the main contract. So it could be piloting a project where you said, okay, let's pilot the project. And if this project indeed is viable, that's when we'll get into a main contract and sign the main contract. So then you'll find this pre-contract phase, or this pilot phase, there'll be, what we call, there'll be the NDA signed, there'll be the term sheets, we'll probably exchange term sheets and sign term sheets. There'll be what we call a pilot agreement. Maybe for like 6 months, we'll have a pilot agreement. And then you'll find these documents will always need to have their own dispute resolution clauses. But what you'll find is the dispute resolution clauses in these quote unquote smaller contracts will be shorter dispute resolution clauses and not as intense as the main contract. So that, and this will cover things like, what if the pilot test fails, or what if confidential information is misused? You don't want to be left with no forum. And a short clause providing for negotiation and then say expedited arbitration, and allowing in the same breath allowing urgent court injunctions is enough to cover at that stage. So there is that consideration as well. Think about what will your pre-contract and your pilot phase contracts have in terms of dispute resolution, and what will the main contract have. And sometimes they don't have similar clauses. Then you'll find there are situations where, which I think I alluded to, where there are multiple contracts in one transaction. And by multiple contracts in one transaction, I mean where one deal will involve multiple contracts. So for example, there'll be the master agreement. So like in the situation where I was saying, someone has bought a core banking software, let's say. So the client will buy the core banking software, but then on the sidelines, there's what we call a service level agreement. There's a maintenance agreement. There may be a data processing agreement. All these are different small agreements, but they all point towards also the main agreement. So then all these have the potential of a dispute arising. So then as you draft, you have to have this, what we call the umbrella clause in the master agreement. And this umbrella clause will govern, you have to be very clear that it will govern all the auxiliary documents with the same seat, when it comes to rules and governing law. And that just makes it easier in terms of implementation. But sometimes people forget that aspect, that there might be small mini contracts, and the umbrella clause that we put in the master agreement should be able to also facilitate these other scenarios and the ongoing relationships. So in closing, I'd say arbitration clauses are not just standard boilerplate, and this is to my commercial lawyers. They're just not standard boilerplate. And in modern contracts, especially, in the evolving fields, fintech, telecoms, data, they are really part of, and many clients are realizing that it's part of commercial strategy, so that if they're drafted loosely, then they become pain points. But if they're done carefully with, the proper escalation steps, with regulatory carve-outs, as I've mentioned, neutral seats, subject matter expertise, and consideration of consolidation across contracts, then they can give parties flexibility and flexibility and confidence. And that's the contribution that I bring from the transactional side. Let's get the clauses right at the drafting table, so our disputes colleagues can have a strong foundation to work with when eventually any disputes arise. Thank you very much, Rosaria, and back to you.
Thank you so much, Catherine, for the insightful session. And we will remember that we no longer have the luxury of copy-pasting dispute resolution or arbitration clauses, that we have to give them much thought, and that we have to think of the end, even when we are in the boardroom drafting the clauses. Thank you so much. And we also appreciate the collaboration between commercial lawyers and dispute resolution lawyers. We are friends. Thank you so much. And that marks the end of our 5th and last session. I see we have around 7 minutes to the top of the hour, and we have quite a number of questions. Thank you so much, Francois, for answering some of the questions that were dropped in the Q&A section. What I will do, I will read one question directed at each of the panelists, so that they get a chance to answer as they give us their closing remarks. And also to remind you that this session was aired on YouTube Live, and it will be available on the ELS YouTube platform for your viewing and for sharing with colleagues or friends. So the first question, I will start with a question that is directed at Edith. It's from, let's see. Kamara Paul asks, are there international guidelines for drafting clauses, for drafting arbitration clauses? Is there a checklist for reference when drafting an arbitration clause? And is it by chance that arbitration clauses are ordinarily the last clause, the last clause, or the midnight clause, or the last minute clause? So Edith, having handled the drafting part, perhaps you can take that. Then I think I will read all the 5 questions. Then the panelists can come in and answer as they give their closing remarks. Then Francois, I've seen you've done a good job of answering the questions on the chat, but there's one I want you to repeat just for the benefit of everyone in a brief way. How do you ensure data protection, privacy, and confidentiality with issues of hacking? So that is from Prudence, and it is a very relevant question, given that we have established throughout this webinar that we can no longer escape technology. So how do you ensure data protection, privacy, and confidentiality? Then the third one, this one can be answered by Oscar and Peter, both of them. So maybe they can just give their brief comments on the same. And it's from Faith Chimchumba. Let me just trace it. She's asking, maybe it disappeared. It has disappeared, but it's about how you ensure enforceability of awards, especially in, okay, I found it. How can you, oh, sorry, this is another one. How can you build expertise in this area? But that one has been responded.
I think I've seen it.
Oh, yes. Yeah, here it is. When it comes to enforceability, how do you ensure arbitral awards are enforced in jurisdictions with uncertain fintech regulations? So because it touches on enforcement and also fintech, perhaps you and Oscar can have a go at it. Then I think the attendees are still typing questions for Catherine, so we can proceed with those ones first.
Okay, to answer that, just choose your seat of arbitration wisely. And that comes at the point of drafting the arbitration clause so that you know, as we said, you work with the end in mind. You know the seat that you're sitting will support your client's position in the event a dispute arises.
Very apt. Thank you so much. And do you mind giving your closing remarks so that we go to the next panelist as we close? Oh, sorry, Peter, you're muted.
Sorry. Thank you very much for this. I've seen there are quite a number of questions on arbitration generally, and we should be able to organize another webinar on arbitration. There are many areas that we can cover, and we can have as many as possible. Being the chair of the ELS ADR committee, I thank Gabriel and everyone else who made this happen. And if you have any issue that you want us to discuss at this level or in a webinar, you can write to the ELS and we'll ensure that we put in place a webinar to just to ensure that we continually learn. I'm also a director of the Chartered Institute of Arbitrators. If you have any question relating to arbitration domestically and you want maybe to be a member or an associate of the Chartered Institute, you can always reach out to me and I'll point you to the right direction. And also, if you need an arbitrator for your tech disputes and energy disputes, you can reach out. So thank you very much.
Thank you so much, Peter. Francois, as you answer the question on data protection, you can give us your closing remarks.
Thank you so much, Roselia. Prudence asked about how to ensure data protection, privacy, and confidentiality with issues of hacking. It's a really good question when you consider technology, but again, we are expert on, creating those platforms. And as someone who needs the platform, you need to ensure that you're looking for the best because they have so many technical. I've seen that when we were developing, the platform for Kia, it requires a strong team that actually are knowledgeable about the field, and they will create for you strong security measures. They will, update your software. They said it's to trick for the hackers, and also, to cover for the weaknesses that the system might have, and also to control who actually access the data, and it is updated regularly. To close, I would like also to thank the ELS and also my fellow panelists for this insightful topic. It was really good and I learned a lot from my fellow panelists. And for those who want to know about, the system, how the system is working, they are free to reach out to us, to KIAC, and then we'll take them through. It was an insightful session. I was so happy to be part of it. Thank you.
Thank you so much, Francois. Next, moving on swiftly to Oscar. Oscar, perhaps you can answer this question which I've just seen. In your opinion, has arbitration resolved the disadvantages of litigation that ADR was supposed to resolve? It's a bit out of the topic, but I guess you can just give it a go as you give your closing remarks.
Thank you, Rosalia. Indeed, I feel arbitration has resolved the challenges we face in litigation. It has resolved the challenge of, like Mr. Njero correctly pointed out, the danger of having a judge who only understands substantive law and procedural law rather than the trade aspects, the customs of the industry. It has also resolved issues of confidentiality because, as we know, court documents, court records are public documents. So then we have confidential processes, especially in the commercial space. That it has also resolved the challenges of litigation in terms of time. It's likely to complete an arbitration in, say, 6 months. Those of the audience here who practice in Kenyan courts will tell you it's impossible to complete a case in 12 months. So then that's how arbitration has resolved the issue of time. Lastly, it also has resolved the issue of having, you see, as parties interact, as they discuss on who will be our arbitrator, where do we meet, where will our arbitration happen. That way parties get a little bit softer to each other. So in terms of business relationships, we can say that they are reserved, and rather than the hard stances that we see parties taking in litigation. So in those few remarks, I believe arbitration has already filled some gaps and addressed some of our challenges that we face in the litigation space. As I close, I hope that answers the question, Rosalia.
Yes,
Okay.
It does. I hope it does for the attendee, but it was quite insightful.
Okay, thank you. As I close then, mine is to thank the ELS, to the ADR committee for this thought to put together such a session, and to our wonderful audience for interacting with us, and my fellow panelists for their informative presentations and their will to share knowledge, their practical experience in this field. And to you, Rosalia, for wonderful moderation. Asante sana.
Thank you so much, Oscar. And now we go to Edith. Edith, there was a question on whether there are universal guidelines that guide the drafting of arbitration clauses. Okay, it seems Edith dropped out of the call. So I will allow Catherine to give her closing remarks, and then we will end it there. Catherine.
Thank you very much, Rosalia. Thank you for the excellent moderation today. And thank you to my fellow panelists, Peter, Oscar, Francois, Edith. Thank you very much for your insightful contribution, and even for our audience for being very engaging. And thank you for the opportunity to share my thoughts. I think for me, my closing remarks would be to just reiterate what I said. Which I hope, if there's one thing that everybody takes away, is that arbitration clauses are not boilerplate, and that they are strategic business tools. They influence risk, investor confidence, and enforceability in the long-term health of business relationships. And my call to us is like, let's not treat dispute resolution as an afterthought, but let's build it into business strategy. And also for the corporate lawyers, let's bring in our litigation lawyers or our dispute resolution lawyers or arbitration colleagues, and let's sit with them early at the drafting stage table, so that that's where we put in contracts, so that at the end of the day, we end up with contracts that actually work in practice if tested. And yeah, that would be my takeaway, and thank you very much.
Thank you, Catherine. Ladies and gentlemen, that marks the end of this webinar. I would like to thank the panelists for creating time to come and share their insights with us, for their thoughtful contributions to today's topics. Thank you so much. And your perspectives have for sure enriched the discussion, and they've provided us with practical guidance on navigating arbitration in today's evolving landscape. Thank you so much. And I urge all the attendees to keep the conversation going. Follow the panelists on LinkedIn. Let's talk. Peter and Oscar have provided their WhatsApp numbers for those who are interested in the slides that they shared during their presentations. Reach out to them, get the slides, get more insights if you wish to. And also remember that this session is available on ELS's YouTube platform. Feel free to rewatch, feel free to share. Thank you so much for creating time to be with us, and I wish all of you a wonderful afternoon. Until the next one.